When a loved one passes away, one of the first questions you face is, how do we transfer their property? Here in California, you have options, and not every estate needs to go through a full, formal probate process. That simple fact can save you a lot of time, money, and stress if you know which path applies to your family. I'm Shanty Soerjono, a California probate and trust real estate specialist, and I work with families through probate every day. My goal is to help you understand which legal procedure applies to your situation, so you can move forward with clarity. First, there's formal probate. This is the standard, court-supervised administration that most people picture. It applies when your loved one owned assets solely in their name, like a house titled only to them, or investment accounts with no named beneficiary, and the estate doesn't qualify for a simpler method. For example, imagine your mother owned her home outright and didn't have a living trust. You would likely need to open formal probate to get the court's authority to handle that property, pay any debts, and eventually transfer the title. Then there is the spousal property petition. This is a simpler court process designed specifically for a surviving spouse or registered domestic partner. It applies when the property, under California law, belongs to that surviving spouse, for instance, if it's community property you acquired together. Think of it this way: your husband passes away, and the two of you owned the family home as community property. You can file a spousal property petition to have the court confirm the home is yours. It's faster and less expensive than formal probate. For smaller estates, you have the small estate affidavit. This is the simplest procedure and requires no court at all. It applies if the estate's total value is below a certain limit and at least 40 days have passed since the death. This is for personal property, like bank accounts, stocks, or vehicles, not for most real estate. For example, if your father left only a few $1,000s in a bank account and a car, you could likely use this affidavit to collect those assets without any court involvement. When it comes to real estate specifically, California has a real property of small value affidavit or petition. This is a simplified court procedure for transferring California real property that meets a low statutory value limit. It might apply to a small vacant lot or a modest parcel of land. The process is much simpler than full probate, but it does require a court filing. Another option is summary probate. This is a shortened probate process available only in specific situations allowed by California law. It's faster than formal probate, with less paperwork and lower costs. However, not every estate qualifies. Your loved one's estate must meet particular criteria set by law. Finally, there is ancillary probate. This comes up when your loved one lived in another state, like Nevada, but owned California real estate, perhaps a rental house in Los Angeles. The main estate is handled in their home state, but California requires this separate additional probate process just to transfer the California property. So, how do you figure out which one applies to you? It starts with a few key questions. Was the home only in your loved one's name with no trust? If so, formal probate is likely. Are you the surviving spouse inheriting community property? A spousal property petition could be your path. Is there only a small amount of personal property, like a bank account? The small estate affidavit may work. Is the real property itself of low qualifying value? Look into the small value real property procedure. Did your loved one live out of state but own property here? You're looking at ancillary probate. And if the property was in a living trust, held in joint tenancy, or had a transfer on death deed, probate might not be needed for that property at all. Why does this distinction matter to you so much? Because the procedure you use directly determines who has the legal authority to sell the property. It dictates exactly what documents escrow and title companies will require, and it tells you whether you'll need to get a court's approval before you can close the sale. Getting this right from the start makes the entire process smoother. One more time, this video is general information, not legal, tax, or financial advice. I'm Shanty Soerjono, a California probate and trust real estate specialist, not an attorney. Please talk with a licensed probate attorney about your specific situation. But if you're a spouse, an heir, or an executor trying to figure out which of these processes applies to you, I'd be glad to help. Reach out for a free, no-pressure probate consultation. I'm Shanty Soerjono, and I'm here to help your family find the right next step.